But anyway, I want to introduce a local criminal defense attorney who is standing up with us against this drug war on medical marijuana, on marijuana period. Mr. Mark Babb.
Thank you, Tanya. You know, I wish I could speak as impassioned as she does. Isn't that great? Everyone, a big hand for Tanya Davis, please. I'm going to try not to take up too much of your time. My name is Mark Babb, and I am a drug lawyer. In my practice, I've had the opportunity to represent hundreds of people that have been accused of drug crimes. Most of them have been marijuana related. It's given me an opportunity to learn a little bit about the law and the enforcement of the law, which is sometimes more important than the law itself, but how it's enforced. This is a particularly interesting time for marijuana laws and drug laws in the history of our country. More volume, is that what you're saying? Or I need to be taller, I'm not sure of the sign. More volume, okay. This is a particularly interesting time for marijuana laws in the United States because 15 states have now legalized medicinal use of marijuana. California, Alaska, Colorado, Hawaii, Maine, Michigan, Montana, Nevada, New Jersey, New Mexico, Oregon, Rhode Island, Vermont, and Washington. And Arizona too. Thank you. So today we're seeing democracy in action in Dayton, Ohio, because we want to add Dayton to that list. We want to add Ohio to that list, rather. The Constitution provides that we have the right to assemble, we have the right to free speech, and we have the right to petition the government for redress of grievances, and that's exactly what we're doing today. We're in support of Ohio being added to that list of states. And I just want to say that I appreciate all of you being here because this is democracy in action. This is sometimes rare, and I think all of you are going to see that 20 years from now you can be proud that you were on the right side of history because it seems absurd, or at least it will at some point to more people, that a person doesn't get to choose the medicine that they want to use if their doctor's in support of it and it's the best thing to help them. Do you agree with that? All right. Whenever you want laws enacted or changed, or whenever you seek redress of grievances, it's good to be educated about the history of the issue and the status of the current legislation. So some of you already know this, but a little refresher doesn't hurt. Maybe this would be a bit of education for some of you. Before the early 1900s, there were no laws outlawing the use of marijuana. In fact, again, some of you know this, but George Washington grew hemp, cannabis. He grew it on his farm. It was a primary crop. The Jamestown, the first settlement in the New World, before the birth of the nation, everyone they were required to grow hemp because it was so important. The first law was passed in about 1906 in Washington, D.C. There were some eastern states, New York and Maine, that passed laws at a similar time. But it was mostly the regulation was on the West Coast. Places like, I've got it written here, Arizona, California, places like that, because the Mexicans were coming up and they were stealing jobs. Or at least that's how they saw it, how little has changed in terms of our perception. But so it was a racial thing. It was the Mexican workers that were coming up from the South, many of them smoked marijuana. So this was just an attempt to keep them in trouble so they didn't have to compete with the Mexicans for jobs. But none of that has anything to do with the plant itself. At one time, there was a case in the United States Supreme Court, and I don't have the cite for you, but basically it said that it's okay, that it's not cruel and unusual punishment to give a person 20 years in prison for simple possession of marijuana. Now, the laws have come a long way since that, because we're not, for simple possession, there was a movement, I think it was in the 70s, of what they call decriminalization. And Ohio is an example of a state that, quote-unquote, decriminalized marijuana. But let's explain what that means. That means that marijuana, simple possession in this state, is 100 grams or less. And it can't be in separate baggies, and then they can get you on intent to distribute. But 100 grams or less is a minor misdemeanor. That's supposed to be the lowest level of law enforcement priority. There's a bunch of other crimes that are more important, and you can't get any jail time for a minor misdemeanor, even if it's a second, third, or fourth offense. But here's the thing. There's another charge called paraphernalia. Has anyone ever heard of that charge? Paraphernalia is not a minor misdemeanor, and it's any instrument, article, or device used for the purpose of smoking marijuana. Now, unless you're smoking this out of your hand, it means that the paper, the pipe, the bong, whatever you use is suddenly can subject you to up to 30 days incarceration. So really they haven't decriminalized anything. In the middle of the last century, there were various efforts by the federal government to prohibit the use of marijuana. In 1970, Congress enacted the Controlled Substances Act, which sets drugs into classifications. And it's hard to believe, but marijuana is actually in the highest level, the most dangerous level, which is supposed to mean that it has no recognized medical use, that it's highly addictive and subject to abuse, and that even with your doctor's help, there's no reason to take it. Drugs in that category include LSD and PCP. Drugs that are below that category include cocaine, and methamphetamines is actually less dangerous in the eyes of the federal laws than cannabis, than marijuana. The American Medical Association has called for Congress to review marijuana status as a Schedule I drug, at least so it can be studied and used to come up with other medicines. But so far, it hasn't happened. Now, at this point, I'd like to remind you of something called the Supremacy Clause in the U.S. Constitution. And I hope I'm not boring you too much, but it's important. I'll get there why. The Supremacy Clause says that if the federal government makes a law, then that's more important than any state regulation. So in California, we saw a situation where the voters changed the law and said it's okay to have these distribution places for people for medical marijuana, but the federal government, under a different administration, saw fit to sue them, to enjoin them, to stop them from doing that, and they were successful. So you say, well, how can these continue? Because it's a question of enforcement. If the federal agents or the federal agencies decide that they're not going to enforce the federal law, then the state laws have a chance to run. They, practically speaking, they're quote-unquote tolerated. So if Ohio joins this list of 15 states, they'll be one of the states that allows dispensaries for people with doctors okay on the use of medical marijuana. It's a question of enforcement. The current administration, the Obama administration, has said that this is not a big priority for them, and that unless there's other problems with the distribution centers, then they're not going to get involved. So this is a good time for Ohio to enact the same kind of laws as other states. Again, I really appreciate Tanya bringing us out, and I want to introduce my partner, my law partner, Charles Rowland, who's a fantastic attorney. He's going to talk to you about LEAP, law enforcement against prohibition, and some other great things. So if you'd give him your attention. Thank you.